First matter to come before the court this morning is State of Ohio versus Robert Ralich. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you choose to do that, let me know. I'm keeping the clock this morning. We have read the briefs, so I'm ready to proceed when you are.
Thank you.
Yes, please.
Police the court, first of all, good morning, and police the court, Ms. Welch. My name is Paul Henneman, and I represent Mr. Ralich. I'd like to reserve a minute. I don't think I'm going to use the whole 15 minutes. I believe this case is fairly simple. My client was charged in the Cuyahoga Falls Municipal Court with assault on a police officer and some other misdemeanors, and it was ultimately resolved at the pretrial that he would enter a plea to, I think, not resisting, it may have been resisting arrest, one of those. In any event, paid all his fines, and I came in to the Stowe court, or not the Stowe court, but into the Cuyahoga Falls court, and asked that the conviction be set aside. And I, in reading 2953-12 or 32, pardon me, there are factors in there that indicate why the appellant or the movant or applicant should be granted or not granted an expungement. And in this particular case, first of all, was he eligible? The answer, in my opinion, is yes. The crime is such that, or the conviction was such that it comes within the 2953 section. Number two, were there any other criminal proceedings pending? And the answer is negative. C, was the applicant, or has he been rehabilitated to the satisfaction of the court? I suppose we go off on a tangent on that one because Judge Hoover did not think he had been rehabilitated. Pardon me. Certainly, the prosecutor did file an objection, and finally, this court, or that court as well, has to weigh whether or not the interest of the appellant rise above that of the government, and it's suggested to the court in this case that it would be. And I say that for this reason. Other than this incident, there has never been anything in my client's past. He's a computer guru or expert or programmer, and he's, as I say, 61. And there's no indication whatsoever that he would not be an aid to society or that his record should somehow be an impediment to him, because it has certainly goofed up his ability to find work. And so I'm asking the court to reconsider, and in reading the transcript, you'll see there was no testimony that would indicate that he had not been rehabilitated. I told Ms. Welch that I have to object to her brief, and I did file this motion to dismiss, only because what she's alleged in her brief were matters that may have been in the police report, but are not matters of record. And for that reason, I think that portion of whatever was in the police report should be excluded from your consideration in this particular case. And for those reasons, I would respectfully request that the expungement be granted. Thank you very much, unless the court has some questions.
I have a question.
Yes, Judge.
So my understanding is that your client appeared at the sentencing hearing.
Correct.
Made a statement regarding what happened on that evening.
Correct. Would be in the middle of the day, Judge.
Or what happened during the day.
Whatever, I understand.
Okay. And that the trial court heard that, took the matter under advisement, and said, I want to look at the police report.
You did say that, correct.
So we don't know, we won't see what's in the police report, presumably, because that was not made a part of the record.
That is correct.
Okay.
However, it was inferentially tried through the back door.
And no one made an objection to the courts looking at the police report, I take it.
That is true. I did not object, and who am I going to tell a judge not to look at a police report?
Sure.
I'd like to, but I can't. I can do it, but of no avail. But go ahead, Judge, I didn't mean to interrupt.
So what we have is, and I'm trying to recall, the judge wrote an entry that explained his thinking, and in that entry, he said, he says that he attempts to explain away his actions on the date as a result of inhaling the substance contained in the smoke, and so on and so forth. So I guess what the judge is writing in his entry is what he has taken from the police report. So you're making an objection to the prosecutor arguing?
Well,
You've got to look at what the judge said.
I'm simply saying to the court, it was not a matter of record. Although, you're right, Judge Hoover did say, I want to look at the police report.
Yeah.
But is that truly before the court at this particular point? And my argument would be that it's technically not properly before this court.
Well, would you agree that if the trial judge looked at the police report, and even though the police report is not before us, saw in the police report things that contradicted what your client had said before the court, that is something that the court could properly take into consideration in making that determination as to whether or not your client had been rehabilitated?
Judge Moore, my opinion would be that the judge should not have done that. I'll tell you why. Because police reports are police reports. They're a subjective point of view from the arresting officer, obviously. The prosecution, first of all, if you read the transcript, Judge Hoover asked an attorney sitting in the courtroom, he said and it's in the transcript somewhere, he said, Mr. Christopher, what do you think of this case? And Mr. Christopher, in his lawyerly opinion, and correctly so, says, well, Judge, if the prosecution was going to reduce, then there must have been a good reason. If they felt that should not have been the case, then so be it. But I don't think the judge should have taken the police report into consideration when he made his opinion. I think he had to make his opinion based solely on what was presented at the time of at the expungement hearing.
Well, of course, the prosecutor takes the position that, yes, they did reduce the charge from a felony to a misdemeanor.
Correct.
And that that really was all the consideration that your client should have gotten, given his the concern about his actions toward the officer.
I agree, but it's twofold, Judge. One, obviously, at the time of, that is set for trial or pre-trial, you obviously have negotiations that go on there. At that point, everything rises or falls according to those negotiations. And yes, maybe the client did get a benefit, but does that preclude that benefit now from his coming in and asking for an expungement? And if all of the qualifications or conditions, rather, of 2953 are met, then even though he got a benefit, I don't think that it should preclude him or the applicant from having his record expunged. That would be my argument, obviously.
Thank you.
Are there any other questions? If so, I don't rest. Thank you.
Thank you.
Good morning, Your Honors. Mr. Henneman.
Thank you.
May it please the Court, my name is Nicole Welsh, and I represent the state of Ohio, Boston Township, in this appeal. I'd like to start this morning just by quoting something that this honorable court has cited to quite frequently in its past decisions. In State v. Smith most recently, in your head note 1, or in paragraph 10, you have said, neither the U.S. Constitution nor the Ohio Constitution endows one convicted of a crime with a substantive right to have the record of a conviction expunged. It goes on further to say, instead, an expungement is an act of grace created by the state, and so is a privilege, not a right. This honorable court, the 9th District, has also cited that same quote in State v. Stringer in 2009, and State v. Futrall in 2008, State v. Simon in 2000, and State v. Hamilton in 1996, all of which I have referenced in my brief that was previously filed with this court. Really, the appellate standard of review here, Your Honors, is that to seal a record of a conviction, you have to look at whether the court abused its discretion. It's a pretty high standard, and this court has previously looked at that standard in State v. Jett and State v. Gilchrist. Under this standard, the appellate court, you 3, 9th District judges, are charged with determining whether the trial court's decision was arbitrary, unreasonable, or unconscionable, not just merely an error of law or judgment. In this particular case, Judge Hoover in the trial court, the Stowe Municipal Court of Summit County, Ohio, took every effort on his part to reconcile Mr. Ralich's contentions on the day of the expungement hearing, which was July 25th of 2014, with what had transpired back on his plea on July 5th, 2012. And he couldn't reconcile the two separate stories. It didn't make sense to the judge that a man would stand before him asking the court to find him rehabilitated when he went from stating, I'm completely and entirely responsible for my actions, and I'm sorry to the officer, and then goes on to plead guilty to both resisting arrest and drug paraphernalia. By 2 years later, would walk into that same court and try to tell the court, Your Honor, I was wrong. I was wrong. I don't remember anything of what happened back then. I'm not a drug smoker. Somebody came into my car and brought this stuff into my car and I threw them out. So he's essentially saying 2 years later that his plea on July 5th of 2012 should not have been taken into consideration, that he was not guilty of any of those crimes. Can you determine an abuse of discretion, or if the trial court decision was unreasonable, unconscionable, or arbitrary, without considering the entire record that was in front of the trial court at the time of that plea?
Did he say at time of sentencing that he didn't do what he was accused of?
No, Your Honor, he did not. As a matter of fact, his pleas of guilty to the amended charges, there was no argument by either party made to change the record, to change the reports, or we did make one brief change to the complaint to take it from the felonious assault on an officer down to the resisting arrest charge. But other than that, Your Honor, no, there was no discussion had between counsel about striking any part of the record.
No, I didn't mean that. I meant at sentencing. Did he say to the court, I'm not guilty of, or words to that effect?
No, Your Honor, he did not.
He said, I don't remember.
At the expungement, he said he doesn't recall.
He doesn't recall the plea, or he doesn't recall the event.
He states that he doesn't recall the events of that evening, but then he was able to subsequently create this hitchhiker story to back up his aberration of his behavior. The state's not here sitting here saying that as a 61-year-old law-abiding citizen, that this wasn't an aberration from his normal behavior. We would never try to argue that. The argument really is that the aberration in his behavior has continued by his failure to continue to take responsibility for his actions. Today we're not here for trial. His time for trial was back in July of 2012. He stipulated to the facts back then when he pled guilty to both resisting arrest and to possession of drug paraphernalia. 2 years later, he changes his tune and wants the court to believe that he's not guilty of those crimes that he pled to in 2012. We did stipulate in our letter, our objection letter to the court, that Mr. Ralich was an eligible offender, and we did stipulate that he had no pending criminal proceedings to our knowledge. However, the one that strikes home for me is RC 2953.32, C1C. The applicant has been rehabilitated to the satisfaction of the court. To the satisfaction of the court. Judge Hoover continued and took it a step further than just the expungement hearing. He went back and reviewed the record. He wanted to make sure, since he wasn't the judge on the original case, it was actually, the plea was granted in front of a magistrate and Judge Hoover signed off on that plea. He wanted to make sure that he had the entirety of the circumstances before him to determine whether or not Mr. Ralich had truly been rehabilitated. He goes on to explain why he felt that he hadn't been rehabilitated. And I could quote for you, but you've both read, or all three of you have read the order of Judge Hoover, where he goes through why he's concerned and what he sees as the disparities between the original behaviors and his current behaviors. The trial court has a significant amount of discretion in determining whether or not a petitioner has been rehabilitated. That's what we have to remind ourselves about today. And they also have an extreme amount of discretion on whether the expungement is consistent with public interest. Part of our argument having to do with factors D and E under the RC statute 2953.32, C1 D and E, is that an officer's safety is paramount. It's probably the only reason I would truly object on something that is otherwise an eligible offender or someone that is otherwise an eligible offender. I've actually had this particular trial court judge expunge people's records over my objection when he found that they'd truly been rehabilitated, because he says that it's not necessarily just one reason for us is officer safety. That's my most paramount reason. I used to be a police officer. When I think about what they face when they go up to a car, unknown, the person that they're going to meet, what that person's going to do, they have a right to at least know that in the past this man has been a little different when it came to his interactions with police officers. That gives them that extra second of ability to process what they might be facing when they approach him in a motor vehicle. So the only reason we objected wasn't that we thought he wasn't rehabilitated. That wasn't a matter for the prosecution to decide. That was a matter for the trial court to decide. It really was that we needed to keep that record because it's paramount to officer safety.
So in effect, you're saying that in those circumstances, there never can be an expungement, no matter how much the defendant, the previously convicted person has changed his behavior and lifestyle.
Not exactly, Your Honor, and this is why, if I might, Your Honorable Whitmore. I always object for that reason, okay, because officer safety is what I'm concerned with. But Judge Hoover will routinely say to me, is it really, is that really an issue? This person has come in, they have owned their error. They have walked into this court and accepted responsibility for their error. They have apologized to the officer. They have had no further proceedings.
And none of that has occurred here?
Your Honor, he apologized initially to get the plea down to the misdemeanor. But then he subsequently steps back from his, hey, I'm responsible for this, to saying I'm not responsible, some third party, ghost, was responsible for my actions. Had he walked into Hoover's courtroom and said, Your Honor, it's been 2 years, and every day of that 2 years I've thought about what a danger I put myself in and what I put that officer in, Judge Hoover would have looked at me and said, despite your objection, I would grant this expungement. And I can stand here before you and tell you this because I feel in my heart, had he come in and owned that, the judge would have granted his expungement over my objections.
And your opinion is that the use of discretion comes into play when the judge didn't give any credit to this claim that he had no memory, and I presume was thus saying he was recanting on that ground?
Right, Your Honor, abuse of discretion could be found if he hadn't considered all of the 5 factors, but he had considered all 5.
What was the recanting? What's in the record on that?
Your Honor, he states in...
I know we can go back to the record, but if you can't remember...
Give me 1 second if I can go back in. In the police reports, which I know Mr. Henneman has objected to, however, it is something that the judge did consider when making his decision, he actually told the investigator that he was entirely responsible, quote, entirely responsible, unquote, and, quote, the police had him dead to rights, unquote. That's what he said at the time closest to the event, which is when your mind is freshest about what's, when something happened. To fast forward 2 years later, he walks into his expungement hearing and for the first time ever makes an allegation that he had a third-party hitchhiker in his car and that he was under the influence of whatever that hitchhiker had introduced into the environment. Thank you. The panel has nothing further. Thank you for your time.
I don't think that my client was denying that he had a confrontation with the police officer. He's not saying that at all. And if you look at the record at page 5, Mr. Ralich addresses Judge Hoover and he says, "It was more than weed, Your Honor. I was having an adverse reaction to whatever he was smoking. I don't know that it was ever analyzed, but I was having an adverse reaction. So I pulled to the side of the median, the side of the road. He came out of the median, he referring to the police officer, and we were nose to nose. I had presence of mind to pull off because I felt I needed assistance, and I honestly don't remember a confrontation with him at all. I have to take my client's word as to what happened. Obviously, the police officer had a different opinion of him, but my gosh, does that mean that this guy, when you view the term rehabilitation, what does that mean? If you have one run-in with the law over a 60-year period of your life, does that preclude you forever from, getting your life back on track? And in my case, there's a sociological aspect to it, that he can't get a job. Well, as a computer guru, the first thing they say, have you ever been convicted? Yeah, I've been convicted. And bam, they run the record on you. And who wants to hire a guy that, has a record? My guy's been on employee for over a year. In any event, that's my position on it. Thank you very much.
I have a question.
Yes, Judge.
So there were 2 charges that he pled guilty to.
I believe so, yes.
And one of the charges was related to drug paraphernalia.
Correct.
What was found in the car. So when he says at his expungement hearing that there is a hitchhiker that was smoking something, is he not recanting on the drug possession charge?
No, not really. I don't think so. It was, the story that my client told me was that he picked up a hitchhiker, and in the process of the ride, the hitchhiker began to smoke something. My client didn't know exactly what it was. There was a confrontation with the hitchhiker. My client said, "Get out of the car." So our position was that what was left in the vehicle was was the drivers. Was the hitchhikers, and that's why we entered a plea to it. May sound convoluted, but that was. I'm sorry.
Because technically it is in possession of it if it's in his car? In other words, you don't have a defense just because it belonged to somebody else at the time?
Well, it would have been, we were raised it at the time, but we hadn't gone to trial, yes, but it's there in the car. You're absolutely right, it's dead in the water, and that's why we pled to it.
So I guess in following up with Judge Hensel's question, if that is what your client says happened, then if the court goes back to the police report, isn't the court, would not you expect the court to be gravely concerned that none of this was told to the officer at the time of the arrest, or that it was not brought up at the time of the plea?
Well, it's a difficult question for me to answer. I have no glib answer. I wish I did. That's the way it was, and it came down. I was at the initial pretrial when the matter of negotiations were on, and at the time, none of us really gave much thought to it. I thought it was a reasonably a good way to settle the case. Certainly, I didn't want a felony arrest on my client's head. And, you know, and when you get a couple of misdemeanors, you say, yeah, why not? What happened, Judge, I have no idea. I have to believe my client. I told that to Miss Welch. You know, what my client may have told the police is one thing. I can see where that might be a concern, certainly for you and certainly for Judge Hoover. But nevertheless, you still get back to the record, and if you look at the record, my client complies with it. And, you know, it's not that when you talk about rehabilitation, what are you going to do with a guy who's 61, has never had an arrest in his life?
Sure.
And that's part of the hang-up here.
Was the negotiated plea agreement, did he have to plead guilty or could he have pled no contest?
Well, I suppose we could have pled no contest.
Well, I mean, was it,
No,
is it in the record that the state for the deal was requiring a guilty plea?
Yeah, Your Honor, it was not requested. In other words, it was not mandated as part of the deal that the client would plead guilty. And in my perception of it, where did I see any violation to another party that I was concerned about, something of that nature? So, yes, there was a confrontation with the police officer, and that's why we entered the guilty plea. But, well, never mind. The issue of rehabilitation, I think he's been rehabilitated, but anyhow, as far as I can. Any other questions? It's a pleasure being in your court. Thank you very much.
Thank you both for your presentations this morning. The court will take the matter under advisement, issue a written decision which will be sent to both sides, as well as posted on our website and the Ohio Supreme Court website.
Thank you very much.
Thank you so much for the opportunity this morning, Your Honors.